you. Good morning and welcome to the Court of Appeals. We have one case for argument today. Your panel today is I'm Judge Donna Stroud. To my right we have Judge Valerie Zachary. To my left we have Judge Fred Gore. Looks like everyone is in place and ready to go. And are you going to do 5 minutes rebuttal? Is that correct? Okay. Just want to make sure I know what it is. Okay. And y'all already have that all set up. Okay. And we are ready to proceed.
Good morning, and may it please the court. My name is Morgan Reese, and I'm here today representing Gemino Healthcare Finance. As I mentioned, I'd like to reserve 5 minutes for rebuttal. Your Honors, Vero is in a bind of their own making. This case ultimately rewards a party who entered into a contract but didn't think it through, and punishes a party who didn't plan poorly. The outcome is ultimately bad for business in North Carolina. This court should seriously consider that when fashioning an outcome here. Now, of course, over the next 25 minutes, we're going to have a conversation. That conversation, though, it's going to zig, it's going to zag, and it's taking us in different directions that can appear contradictory and inconsistent. But the reason for that are the orders in this case. The first order from May of 2024 is legally impossible and factually inconsistent. It's no surprise then that the October order follows the same pattern. And of course, flowing from these orders are three real issues that we've raised for the court's attention. The first issue relates to this concept of conversion. Under the court's May 2024 order, the conclusion that there were conversions based on that fall outside of statute of limitations is legally inconsistent and flawed. Vero's claim for conversion is time-barred because the trial court's own findings established that every alleged wrongful sweep occurred outside of the 3-year statute of limitations. And the two that fall within that time period simply do not constitute conversions under the law.
So is it your contention that any money that was paid should be applied toward those last two sweeps?
Yes, Your Honor. So
well, why? Why should it go to those last two sweeps and not to the earlier sweeps?
Yes, Your Honor. So those last two sweeps are factually different. April 24th and 25th are the two that we're talking about here. So I'll point the court to a couple different reasons why those are different. First of all, those two sweeps were done at the behest of Blue Ridge on the Mountain. Now, in the record, at Documentary Exhibit Volume 2, and it's going to begin at page 2002, and it goes all the way to 2006. There's a series of email communications between Levi Rudd, who's the CEO of Blue Ridge on the Mountain, and Jim Offit, who is the CFO of Vero. Those two communications happen over the course of April 24th and 25th. Excuse me, just April 25th, Your Honor. Over the course of April 25th. And they're talking about the money that's being transferred. Vero indicates that they can't get into the lockbox, which is the bank account that has the money the funds are being put in by Medicare and Medicaid. And Levi Rudd responds and says, I'm having Gemino sweep those funds as a favor to me, because otherwise the funds are just going to sit there. Jim Offit acknowledges this, and he thanks Blue Ridge, he thanks Levi for his help in figuring this part of it out. So that's the first reason why these two are different. But then factually, Your Honor, you'll also see in the record.
So they're different, first of all, because they had permission.
Yes, Your Honor, they're different. But to be clear, Your Honor, that email chain is between Blue Ridge on the Mountain, not Gemino. Blue Ridge on the Mountain and Vero.
Oh, okay. I
just wanted to make sure that was factually distinct for the courts. But that still doesn't impact here, because the whole point of a conversion is, of course, that the money's being taken and deprived of the owner and taken away from the owner. So here, I'm sorry, Your Honor, the court has a question.
Well, let me clarify one thing. So, okay, that's some of the documents, and obviously there's a lot of those, but now we have an order with a lot of findings of fact. And as I see it, none of them are really specifically challenged as unsupported by the evidence.
Your Honor, that's correct.
Although you might say some are logically inconsistent, but not really challenged. So are there findings in the order about this, the emails you're talking about here?
There are no findings. And the only factual finding that relates to the April 24th and 25th relates to, I can find it in the record, Your Honor. All it simply says, Your Honor, is that there were funds that were paid into the account on that day from Medicare and Medicaid. It's finding number 39, Your Honor, on record page 90. It talks about Medicare and Medicaid making payments into the lockbox account for services that Vero performed, and that Gemino then swept the payments and into its own account. But of course, what that factual finding also doesn't take into account is the fact that that money on the 24th and 25th was swept into a different account that belonged to Gemino. And I think that's also important for this court to consider when evaluating that, because that demonstrates that these sweeps are different than the other ones. The April 24th and 25th ones were swept into the operating account of Gemino rather than the concentration account, which goes to support this email chain that I pointed out to the court, that these monies were being swept for the purposes of giving them to Vero, because Vero couldn't have access to that bank account at that point in time. And that's really exactly what Jim Offit says in his email, is we're working with the bank to get access. And the whole reason why Vero couldn't have access to this bank account arises out of these series of agreements that are between Blue Ridge on the Mountain and Gemino related to these particular bank accounts. And what they really say is that you have to have 30 days for that bank account to be able to transfer out of the title that it's currently in. So it's really no surprise that there was this delay in transfer. All of that to say, the April 24th and 25th transfers really don't fall under the definition of conversion. Conversion, of course, is defined as the unauthorized assumption and exercise of the right of ownership over goods or personal chattels belonging to another, or to their alteration of their condition, or to the exclusion of the owner's right. And that's from Peed versus Burleson, a case out of our Supreme Court in 1956. So the essence of a conversion is really the wrongful deprivation of the owner. And that's simply not what happened for the 24th and the 25th. But Vero really wants to have it both ways. They want to say in one half of their brief that we should essentially start from the beginning, and all the monies that were transferred should start from the beginning of the money that was taken. But really, when we have these delineated transfers on the 24th and the 25th, what they show is that that money went back to Vero. So that's why those two transfers don't constitute conversions, such that even if they fall outside the statute of limitations, or excuse me, within the statute of limitations, they really can't satisfy that here. Turning to the other alleged conversions in this case, of course, we're talking about a statute of limitations that's 3 years. So for the court's purposes, we're really working from April 18th of 2019 forward. And that's really what we're talking about. So a claim accrues when, as I mentioned, there's an unauthorized assumption and exercise of ownership to the exclusion of the owner. So what we really have is, beginning from April 18th and working backwards, anything before then simply can't fall within it. Now, of course, the trial court's order relied on this concept of demand and refusal. But the problem with that is the findings that the trial court made in this case don't factually or legally support a conclusion that a demand and refusal was necessary. When we see these concepts of demand and refusal in our case law concerning conversion, we really see them more in the concept of bailment cases, where someone is holding property for someone else. So there's really not a clear indication that the holder of the property is going to do anything to the detriment of the owner. Now, Vero and the trial court both rely heavily on a case called Hotch versus Young. Hotch versus Young, though, is distinguishable and really supports the conclusion that we are discussing here, which is that That case had to do with stock for a swim club, in which the plaintiff's stock wound up basically in the defendant's hands, and the defendant was holding it. But there really wasn't any evidence in that case that when the defendant informed the plaintiff he had possession of the stock, that he indicated any intention to retain it against the plaintiff's right to convert it to his own use. And further, the defendant came into possession of that stock lawfully. So when there has been no wrongful taking and the defendant comes into a rightful possession, then of course demand and refusal will be necessary to prove the existence of the tort of conversion. But here, the trial court's findings don't support that conclusion, because what the trial court found was very evident in this order. It is replete with examples about how the trial court viewed the facts here. And these are all based on Vero's own arguments. Gemino, findings of fact 61. Gemino had no legal right to the reimbursement for services that Vero provided. The credit agreement did not allow Gemino to lend against Vero's AR. That's finding of fact 8. Finding of fact 20, under the operations transfer agreement, Blue Ridge on the Mountain agreed to hold any third-party reimbursements in trust for Vero that services provided after March 1st. Gemino knew the payments after March 1st included payments for Vero's services. Gemino had notice of the UCC statement. I list all of these to show the court that the court's narrative from May of 2024 is very clear. Gemino, according to the trial court, had no right to these funds that was in the lockbox account. Those, according to the trial court, belonged to Vero. So when the court concluded that there was a conversion, but it depended entirely on this concept of demand and refusal, that is inconsistent with the concept of conversion in our law. And it's also inconsistent with the facts. Because the way the trial court tells the narrative and the way its factual findings tell a narrative here as involving Gemino, the moment they swept those funds, according to the trial court's order, converted them. Because the trial court focused heavily on the fact that Gemino swept them and then applied them to Blue Ridge's on the Mountain's debt, which was part of a larger $2.5 million revolving line of credit to a larger entity called Blue Ridge that had 3 subsidiary entities within it. But for the trial court, being able to sweep it and apply it back to that debt, that was using the funds against the owner of Vero, essentially. But the trial court's conclusions of law don't support these factual findings, and therefore they're legally impossible. Because according to the trial court, the conversion happens the moment that Gemino sweeps the money.
Is your contention that when they swept the money, it was initially lawful?
According to the trial court's order, it wouldn't have been, Your Honor, because the trial court concludes that only Vero had a right to that money that was earned in that bank account. Our narrative throughout this whole process has been contrary to that, but of course the trial court didn't adopt our narrative here. So the question that this court is answering is whether these findings of fact can support these conclusions of law, and they just simply can't. Because according to the trial court, the minute those funds were swept, that was a conversion. Its conclusion otherwise that a demand and a refusal was necessary is simply not supported by the law. Ultimately, Your Honors.
Are you talking about only the last 2 transfers?
No, Your Honor, I'm talking about all the transfers.
Okay.
Because no matter which way I think that to delineate the two, the transfers before April 24th and 25th are of a different nature. The 24th and the 25th, as we've discussed, were done to give the money back to Vero. Vero admits that they got the money back. The other transfers are a different entirety. Now, Blue Ridge on the Mountain had this operating agreement with Gemino, where Gemino would sweep the money, apply it to the debt, and then advance it back to the entities. And that's just what happened in this case. But the trial court made these findings that just can't support the conclusions of law here. They're legally impossible and just inconsistent with the outcome.
So the statute of limitation argument doubling back to that just to make sure, is that being argued to all of the sweeps or just, or excluding the last two because of the time frequency, the recency of the last two? Or is there an argument for those being at issue, or is it the earlier ones?
The pivotal date for this court's consideration for the statute of limitations is April 18th, because that's April 18th, 2022 is really when the statute of limitations would have applied backwards. So, but I'll say it to the court also. Vero offers sort of two analysis of all the money that has been swept here. The first is that you calculate from the beginning, and all the money that was given back to Vero starts from the beginning. So under Vero's one theory, perhaps even the money that was swept in April could be protected and outside the scope of the statute of limitations. I think perhaps the more logical conclusion would be the money that was swept on April 24th and 25th is clearly delineated on those 2 days, and we have evidence to support that the money went back to Vero. So that's probably a cleaner way for the court to evaluate it. Now, of course, the conclusions of law are not supported by the findings of fact. Therefore, this order is legally impossible and logically inconsistent. We would ask the court to reverse on that ground and remand the case. The court could also find, as a matter of law, the statute of limitations bars most of these conversions, alleged conversions, and then the 24th and 25th sweeps simply don't qualify. And that would really end the court's inquiry. But even if this court wants to go beyond that, there are still some issues that merit consideration. Of course, within this case, we have the issue of punitive damages. And that is reviewed by this court for an abuse of discretion. And it must
I'm sorry. Let me ask one thing before you go on.
Yes, Your Honor.
Okay, so you say, find that statute of limitation bars the previous, the 24th and 25th aren't conversions. Okay, and that would be the end of it. But are there any findings of fact that the trial court made that would even allow us to say that the 24th and the 25th sweeps, I mean, how would we deal with those under the findings that we have?
Yes, Your Honor. The April 24th and 25th findings, by Vero's own admission in their briefing, they admit that they got the money back. And so I think that admission is important because what it talks about here is, that's enough for this court to be able to reverse. I also think that this court can, if this court were to determine that there isn't a sufficient finding, this court could remand for findings to be entered specifically as the 24th and the 25th. Because the findings don't support the conclusion, but they also don't prohibit the conclusion here. So we would say that by Vero's admission that they received the money, this court could make that legal conclusion that they don't qualify as conversions. That being said, if the court wished to remand to consider, for the trial court to consider and enter proper findings of fact, it could also do that.
All right, go ahead.
Thank you, Your Honor. Your Honors, the other issues that we have in this case, of course, relate to punitive damages and attorney's fees. So if this court were to not agree with Gemino's arguments that, one, these are barred by the statute of limitations, or two, that the 24th and 25th simply don't constitute conversions, we do arrive at this question of punitive damages. Now, punitive damages, of course, have to be based on competent evidence, but here, there really wasn't any. Punitives, of course, have to be based on, or here they were applied on General Statute 1D1-15. So willful and wanton conduct is the conscious and intentional disregard of and indifference to the rights and safety of others, which the defendant knows or should have known is reasonably likely to result in injury, damage, or other harm. Now here, the court relied heavily on something called a remittance statement. Now really what that is there are statements that are produced by one of two governmental entities. Now in this case, we have the North Carolina Department of Health and Human Services, or we have something called Palmetto GBA. North Carolina Department of Health and Human Services is connected to the Medicaid, as well, while the Palmetto GBA is connected to the Medicare entity. So essentially what this is, when you have an entity like Blue Ridge on the Mountain or Vero operating a skilled nursing facility, they provide services to folks who are either covered by Medicaid or Medicare. They submit it into the system. And then the system, whether it's Palmetto GBA or North Carolina Department of Health and Human Services, generates the documents and determines how much money they should be paid. Then that's provided back to the service provider, essentially. The money then is transferred into the lockbox account accordingly. So here, we had a series of documents that were introduced by Vero at trial. What the court refers to as remittance statements. The problem is that the whole admission of these remittance statements relied really on one man's testimony. That was the CFO of Vero, Jim Offit. Now, Jim Offit neither put the information into the system to submit it to these entities, nor does he work at the entities that created the documents, nor did he receive them on the back end. So Jim Offit really was the sponsoring witness for these documents, and he was more of a supervisor. He had people who were part of the company who were doing this work, but Vero used Jim Offit to introduce these exhibits over Gemino's objection. And that's problematic because Vero introduced these under 8036, which is, of course, the business records exception to the hearsay rule. Now, the problem is that requires testimony by a witness who's familiar with the records and methods under which they are made. Now, Vero points to a case, State versus Sneed. State versus Sneed involved a police officer who was using, I think it was NCIC, to enter information into a system to search about a criminal defendant. They then get the information back from the system that they're using, and then that's introduced by the state at trial as a business record. Sneed's different than what we have here, because Jim Offit is not the one who's entering this information into the system. Someone else in Vero's back room, if you will, is doing that work. So even if State versus Sneed was going to apply here, it really is distinguishable in that, as I mentioned, Jim Offit's not the one entering the information. Really why this is important is, of course, 8036 is designed to prevent the admission of hearsay. So the trial court relied on this evidence that was admitted under the business exception rule, but it doesn't really, the business record exception rule, but it doesn't really satisfy that standard. And because it doesn't satisfy that standard, it really shouldn't have been admitted, and therefore it can't be considered competent evidence. So if you take all of that away, really there's nothing left to support the trial court's findings that Gemino acted in any sort of willful or untoward way. Even still, even if this court were to determine
So
that
you are challenging those findings?
well, Your Honor, we would be challenging that as it relates to punitive damages, as to the admission, because the punitive damages are so heavily founded on this concept that Gemino should have known. Gemino should have looked at these statements. There's, of course, findings of fact, even if there's competent evidence to the contrary, or reviewed by a certain standard on appeal. And we certainly understand that, Your Honor. So we offer this to say that this isn't competent evidence to support this finding here. Now, I would point the court to the fact that there, of course, is other evidence in the record to suggest that Gemino, by industry standards, really shouldn't have even looked at these documents, these remittance statements, to identify. Testimony from one of Gemino's VPs, Stacey Allen, who the expert held out to be, an expert, Gemino was an expert in the industry, said that they never looked at the remittance statements. So I think that the court can conclude that the punitive damages are improperly awarded for really one of two bases, which is either it's not based on competent evidence, or that it's just not sufficient based on the conduct here.
So which findings would be affected?
I'm sorry, Your Honor.
Which findings are you specifically challenging?
Your Honor, the court begins to talk about punitive damages on pages 190, record page 194, beginning at 65, paragraph 65 for findings of fact. It talks about how Gemino did not take steps that reasonably could have taken to investigate the post-closing amounts. And then it goes on to make a series of findings talking about specifically as it relates to punitive damages. And those go on through paragraph 68. Your Honors, all of this to say is that, and I will just make a note for the court that we did object at the very beginning of trial to both Medicaid and Medicare. But during the course of the trial, we only maintained the objection as to Medicaid. Medicaid was a larger amount of money anyway than Medicare was, but I do just want to flag that for the court as it's considering this sort of argument in this case. Even still, viewing these facts that have been found, considering the 8036 exception, punitive damages just simply aren't warranted in this case. They don't compel the outcome. They're not the compelled outcome from the facts here. And then finally, Your Honors, we have the question of attorney's fees, which unsurprisingly is an order that's riddled by conflicting conclusions of fact and law. And of course, the problem with the attorney's fees question is that ultimately the trial court's order in that case was similarly legally inconsistent, in that in one breath it determined that the no-claim defense presented by Gemino was proper, but then it wasn't proper to use it for the counterclaim. We would say that this case just really doesn't rise to the standard of attorney's fees, and that it does not present one of those cases that is an abuse of our legal system. That's just really not what we have here. There wasn't any controlling authority from the North Carolina Supreme Court that would have clearly foreclosed this action by Gemino and its counterclaim, and it just doesn't really rise to that standard. Your Honor, unless the court has any questions about the attorney's fees, I will briefly conclude, and I would ask to reserve the remaining part of my time for rebuttal.
Did the trial court award Vero 100% of the attorney's fees it requested?
They did not, Your Honor. They did cut it down, and it was delineated in that order. I'm happy to have any further discussion about that if the court would be interested. Thank you, Your Honor.
Thank you.
Your Honor, in total, we would ask the court to reverse, and I would like to reserve the remainder of my time. Thank you.
Thank you.
May it please the court, my name is Daniel Trimmer and I represent the FLE Vero Health X LLC. It may be useful to start with the timeline of the sweeps that occurred in this case, especially considering Gemino's first argument as to the statute of limitations that really narrowly focused on those April 24th and April 25th sweeps without properly acknowledging the overall context of what was happening during this time. And I think that context is important. So Vero and Gemino discussed Vero taking over the operations of this particular facility from Blue Ridge before March 1st, 2019, when it actually occurred. And Gemino knew that transfer was going to take place as a sophisticated lender. This case is unique in that Gemino, as one of the defendants, has experience in both representing an exiting operator, such as this case with Blue Ridge, plus an incoming operator that Vero held in this case. So it knew how these transitions work and knew the roles and how things go. On March 1st, Vero began to provide services to which Medicare and Medicaid would make payments into the Blue Ridge bank account for the outgoing operator's services here at Vero. And then March 18th was the first date on which Gemino began to sweep the money that represented payments that were made into the account for services that Vero provided. Then again on April 1st and April 3rd, Gemino made additional sweeps for, again, services that Vero was providing. On April 8th, Blue Ridge and Gemino signed a release agreement that stated that Gemino released its lien and security interest and terminated Blue Ridge's obligations under the credit agreement that it held with Gemino as of April 8th, 2019. After signing the release, Gemino continued to sweep funds in the Blue Ridge bank account. Again, that occurred on April 10th, 15th, 17th, 24th, and 25th. All of these dates were dates where Gemino swept Vero's funds into its accounts. So in total, Medicare and Medicaid paid a total of approximately $340,000 into the Blue Ridge bank accounts for services that Vero performed, and Gemino swept those into its own accounts. But then on April 18th, 24th, 25th, and 30th, Blue Ridge paid Vero a total of $215,490. That's where we're left with this balance that represents the principal of this case, where Vero sought recovery for the $125,000 approximately that it never received. The payments then stopped coming from Blue Ridge, and so then about a month later, April 30th was the last payment date, Vero reached out to Gemino. They scheduled a call, and on May 31st, the most important date in this case, we believe, happened when Vero spoke. The CEOs of both companies spoke. Vero explained what had happened. Gemino was familiar with this transition and how things work, and actually said, we're not going to return the money. We already closed out this loan. We can't do anything for you. But can you send us more information? So Vero responded to that shortly thereafter. They actually sent the CFO, Jim Moffitt, who testified at trial, sent Gemino the requested information detailing, hey, here's how we're owed this much money. Unfortunately, after that communication, Gemino didn't return any of the money.
Before that communication, did Gemino have any way of knowing that it was taking money that had actually been earned by Vero?
So up to that point, Vero couldn't show that, but through discovery and trial and the depositions, all of the Gemino witnesses admitted to a T that the way this works is after a certain point, the sweeps begin to incur on the incoming operator, and they would have concerns about continuing to sweep an account with the incoming operator's funds hitting that account. But they all said that this usually gets worked out. This usually gets worked out. Well, the way this should have worked out is Gemino should have taken Vero's accounting into account and worked it out, returned the money to Blue Ridge.
What about the remittances that they receive from Medicare and Medicaid?
Right, and so on the remittances, these are records that are commonly kept in any provider situation. In fact, if you look at the credit agreement that Gemino had with Blue Ridge, it gives Gemino the right to look at those on a weekly basis. Their CEO would say, yes, we keep track of these on a weekly basis so we can adjust how much we're lending to. The remittances form the basis for that lending agreement. They adjust it based on how much is being paid and how much is being services are being provided. So the trial court's finding of fact saying Gemino should have known, they had the ability to check, but they stuck their head in the sand, is reflected in the record, and I believe is a supported finding and isn't being challenged here. So they could have looked into the remittances at any point had they wished to.
So the findings, so the trial court pretty much found, or did find, certainly that Gemino knew, right? So number 42, despite knowing Vero was owner of the funds deposited, including full knowledge of the OTA as early as March 21st, Gemino nonetheless swept funds. Gemino was aware in the next one that the funds were owed, et cetera. So according to the trial court's findings, 42, 45 is clearly that they knew that this was a wrongful, basically they were taking that money wrongfully.
Yeah, I think the key distinction that is being glossed over in the arguments here is there was no indication from Vero's perspective that anything was amiss until that May 31 phone call. Because again, Gemino's an experienced lender, one of the biggest, if not the biggest in this space. They've handled transactions on both sides. They worked through these things. The April payments that Blue Ridge was making covered the earlier sweeps. It was happening within a month. And so when you don't see those payments being made, that's when the May 31 call happened. And that's when we discover for the first time, well, Gemino's taking a different tact here. They're saying they've closed out the loan with our money and are not going to return it.
So it sounds like you're saying that the conversion happens when Vero realized it, instead of necessarily when Gemino did it. Now,
well, and it's hard to say because the intent here expressed by Gemino on May 31 for the first time was never made known to anyone. So if they had this thought in their mind, they never expressed that they were intending on withholding Vero's money. Up to that point, again, money was flowing. They were returning Vero's money. And so I think the act of conversion would have happened when the demand, and again, we can get into the Hock v. Young case, which I think describes this, where if the person who holds the stock certificate doesn't communicate that they're intending on taking it for themselves, they're just possessing it, then that doesn't start the clock. It starts the clock when you made it known, I'm actually going to take this for myself. And that's really what happened here, is the clock didn't begin to run until May 31.
But that's when the person came into possession of that lawfully, right? It ended up with them, they didn't do anything bad, you know.
In the Hock v. Young case, they came into possession earlier, and this was the same argument being made in that case between the statute of limitations. And so here, in fact, I don't think we want to change the law from Hock v. Young, because in this industry, it is, again, common for the lender to take possession of the funds of both the incoming and outgoing operator, but then it gets worked out. There's no intent to deprive the incoming operator of those funds. And again, that was expressed through the conduct in this case until April 30th.
So did Gemini, initially, did they lawfully acquire the funds?
So I believe their initial acquisition of the funds was contemplated not only by the terms of the operating transfer agreement between Vero and Blue Ridge, where it said Blue Ridge is holding those funds in trust, right? I believe that was referenced in the initial argument here. They're holding those funds in trust. Well, if Blue Ridge is using Gemino as its agent, you know, if there's a Baylor-Bailey relationship, it's saying, hey, Gemino, sweep these funds for me. But it didn't tell, there's no evidence in this case that Blue Ridge told Gemino to take Vero's funds and use it towards my loan, right? So that's the next connection that would need to be made.
But the initial acquisition.
The initial acquisition, I believe, was
lawful.
contemplated by not only the industry standard in the contract, but Vero admits, yes, we expected the funds to be swept. We did not expect them to be withheld forever. And so I think that's the distinction here. And again, they have to make this argument because they have to fit their case into this narrow timeline of when the case was filed versus those sweeps. But if we just use the May 31, 2019 date, the order does not need to be revised. It's consistent. We would ask that it be affirmed. They argue that the trial court order itself says that Gemino never lawfully possessed the swept funds. If you look at the cited provisions of that order, I don't believe they use such language. I don't believe it actually gets into that fine of detail. I believe it's an incorrect interpretation of the cited provisions. It does not state that Gemino converted Vero's fund at the moment of the sweep, right? It does not say that. Again, this is likely because of the OTA, the industry standard, all the testimony from the case here, that's not what any of the parties thought it was. All right, so then if another key fact in this case is the prior experience of the parties. So none of the parties, including Gemino's own witnesses, said they had ever experienced a lender refusing to return funds for services performed by an incoming operator. And that was admitted by the Gemino CEO, Tom Schneider. So prior to May 31, there was not only never any experience of that happening before, but that was the first time that they told Vero that they were intending on taking Vero's funds. Before its demand to Gemino, there was that 1 month delay. Vero needed the sufficient time to calculate how much it received from Blue Ridge versus how much was left remaining. And I think, therefore, all of this evidence points to the May 31, 2019 date as the date of the refusal and as the date of the claim accrual. I'd like to briefly read from the Hock v. Young case because I think there's several passages here that are helpful. So in this case, again, like our case, the court says there was no evidence that when defendant informed the plaintiff that he had possession of the SOC certificate, that he indicated any intention to retain the same against plaintiff's rights or to convert it for his own use. The court then goes on to cite the North Carolina law on personal property and saying the mere receipt of possession of the chattel from a third person with an intent to acquire a proprietary interest therein constitutes conversion without a demand for its return by the owner. But it goes on to state a subsequent refusal to surrender the chattel on demand may constitute a separate act of conversion. The owner may elect to treat the defendant as a converter either from the receipt of the chattel or from his refusal to deliver it on demand. That is what we've done here. Vero has elected to treat Gemino as the converter on the date of the refusal to deliver the funds on May 31, 2019. I believe Hock v. Young and the holding there are controlling here. All right, moving now on to the alternative. If this court does find that the claims accrued on the date of the sweeps, the April 24th and 25th transfers would still be within the statute of limitations. And those sweeps are conversions because, again, Gemino returned the funds to Blue Ridge, but Blue Ridge had paid Vero those funds that were applied to the first conversions, right? The first set of transfers. And there's no authority that I heard that requires this court to adopt Gemino's accounting of this, where you must apply the last received payments to those April 24th and 25th transfers. Effectively doing that would deprive Vero of a remedy in this case. And I don't believe that there's any authority that requires this court to make that finding. There's an argument that the sweeps on April 24th and 25th were for Vero's benefit, citing to a April 25th email. They haven't explained how they could make a transfer for Vero's benefit with, I believe Vero's authorization was even implied for an email that was sent on April 25th. Certainly the April 24th transfer wouldn't apply if they're relying on an April 25th email. The other thing that's interesting about this email is it's really more of a conversation as to what Blue Ridge is telling Vero what they're doing, right? Blue Ridge is informing Vero that they are asking Gemino to make certain transfers, but Vero isn't authorizing or making the request. They're actually saying to Blue Ridge, how can we get Gemino to cease their sweeps? That's what Vero asked. Vero asked to cease the sweeps, not to keep making them. And so again, these are April 24th and 25th transfers are conversions, and we would ask that at most this statute of limitations argument, if the court finds that they apply on the date of the sweep, would apply to approximately $4,800 of the amount that's owed, leaving a balance of still over $120,000. All right, turning now to the arguments regarding the punitive damages. First, I believe Gemino argued that we failed to properly plead that. They didn't even address it in their reply brief, so I won't address that here. I think it was properly pled. The other argument we heard today was that it's based on incompetent evidence. So this relates to the Medicare and Medicaid remittance evidence. Vero has shown in its briefing that Gemino did not object to the admission of records that both concern Medicare and Medicaid. So these are exhibits 56, 57, 58, 59, 60, 66, and 66A. And there was related testimony about these exhibits. So Vero's CFO, Jim Offit, he testified about each of these exhibits, how the remittance process works for Vero, how the employees input the information, how they're regularly conducted business records. And they didn't object to any of that testimony related to those exhibits, and also which talked about Medicaid. So the argument that Gemino is making is that it objected to the Medicaid evidence, that it preserved those objections. But this is simply incorrect. They failed to object to the evidence of exhibits 66 and 66A. They were admitted without Gemino's objection. And Mr. Offit testified about those exhibits, and they contain references to Medicaid remittances. They actually list all of the remittances. And so if Mr. Offit is testifying about how much the Medicaid remittances were, they needed to have objected to those as well, that testimony in those exhibits as well, but failed to do so. So again, as
which
well as
ones did they object to?
it was exhibits 50 through 55.
Okay.
So it's well established that the admission of evidence without objection waives prior objection to the admission of evidence of a similar character. That is exactly what we have here. So Offit did testify about the Medicaid remittances, and there was no objection. Even if they had, so the records evidence did qualify under the business records evidence exception to the hearsay rule. So first, Offit was a very qualified witness. If you go through the trial transcript, I think the trial court makes remarks about how impressive he was in terms of knowing how the remittance process works in a very fine detail. He goes through how they're entered into the system, how they're regularly conducted records that are relied on by both the government and these providers to get people paid. In its reply, Gemino admitted that Vero's CFO testified as to what he understood the business system was and how it functioned, but argued that wasn't enough to satisfy. And again, they're trying to distinguish State v. Snead. I have a different reading of that case. So in State v. Snead, a detective was a qualified witness under Rule 803, subsection 6, despite being neither the record's custodian nor affiliated with the entity, the NCIC, that created the printout that the detective used, because his testimony showed the regularity of the preparation of the records and reliance on them by their preparers or those whom they are prepared for. So the detective testified concerning the foundation for the printouts from the NCIC database, even though he did not input the information in that database. So that's a key thing I think you heard, that Mr. Offit didn't input the information into the remittances. State v. says the detective was fine not to have done that. Because the detective's testimony established the regularity of the preparation of the records and his regular reliance on the records, the detective was a qualified witness. And here too, for Mr. Offit, Vero regularly inputs this information. They want to get paid promptly, and they do rely on this remittance evidence. These remittance evidence, the trial court in the order establishes that, well, the record establishes that these are billing records that identify the dates and types of service and the payment information concerning the services provided to the patients. Vero employees input the information when Vero provided the service to the patient for purposes of billing Medicaid and Medicare. They include the dates of the treatments, and so they're self-authenticating as to the timing element of the business record exception. And then persons with knowledge of the information in the remittances provided and reported their information in these remittances. The employees with the knowledge of the services Vero provided submit this information used by Medicare and Medicaid to pay Vero. These are all conducted through regularly conducted business activities to document patient services. So the source and method of these records is trustworthy because, again, Vero employees input the information in a timely manner consistent with the services provided. So the punitive damages award is based on competent evidence. Also, we believe that the findings in the analysis that the court went through to talk about how it believed Gemino engaged in highly egregious conduct. It goes into a detailed 71 supporting findings of fact. It goes through the factors of the punitive damages award. We believe that the trial court is well within the law here to award punitive damages. And again, I think what the really key fact here is how sophisticated Gemino was and the admissions from their own witnesses in this case that hung them. So not only was one of the things that they raised was, well, we don't know about these remittances, but then at every stage we asked them, well, you knew at a certain point that this was Vero's money. You knew at a certain point that you kept the money and paid down the loan balance. Well, yeah, we have concerns about that. Well, it was our job to look into the remittances. That's what their CFO testified. I expected people to do their job. But the people, when we were asked, did you do your job? They said they did not. Stacey Allen testified, we didn't look into the remittances. Miriam Gallagher said, well, I would need to look at the operations transfer agreement to understand how this interplay occurred. They sent it to her. She didn't read it. We sent them the operations transfer agreement before the May 31 call. Their CEO said, I didn't read it. Stacey Allen said, I read parts of it after the call. But at every stage, this is the highly egregious, willful, and wanton behavior exhibited by Gemino, who knows better. This is not an unsophisticated lender. They know better. So we believe that this justifies the award of punitive damages, and they only really stopped sweeping once they paid down the defaulting borrower. That is another egregious fact here is they said to Gemino during this period of time before May 31 that we're not lending to you anymore, you're in default. They use the words, you're in default. But then they used Vero's money to reduce that risk. Finally, I'll turn to the attorney's fees portion of the argument. So for this, Gemino filed a counterclaim for tortious interference with contract in October 2022. The factual basis was that the very fact of filing the lawsuit interfered with their credit agreement with Blue Ridge. However, at every stage, no one has ever said that this agreement was in place in 2022 any longer. In fact, Gemino's CEO admitted that Blue Ridge had paid off the loan. Stacey Allen admitted that by May 29th, 2019, Gemino was, quote, completely paid out of our entire credit facility and had no longer a relationship with Blue Ridge. The law on tortious interference does not allow you to bring such a claim. The trial court correctly ruled that Gemino knew or reasonably should have known that there was really no justiciable issue of law or fact. Based on the lack of factual support, there really was no agreement in place at that time, and a lack of factual support that Vero acted without justification. I mean, they admitted that the funds deposited into the Blue Ridge bank account wouldn't have been Blue Ridge's collection. That was from Miriam Gallagher. So there's no basis for them to allege a tortious interference with a contract that did not exist at that time. The only damages that were identified by Gemino in its tortious interference counterclaim specifically identified attorney's fees and litigations costs. And under settled North Carolina law, that's the Robinson v. Hope case in 2011, they're not ordinarily recoverable as damages. And then finally, we raised that the Norr-Pennington doctrine barred Gemino's counterclaim because the entire basis of the claim was Vero suing Gemino, which is a protected petitioning activity. Only sham lawsuits, objectively baseless suits that are no reasonable litigant could realistically expect to succeed on the merits are exempt from this protection. And since Vero prevailed in this case, a winning lawsuit is by definition not a sham lawsuit. So here, Vero's lawsuit against Gemino could not form the basis of a tortious interference with contract claim because it was not a sham and therefore a protected petitioning activity. The amount of attorney's fees was challenged. We sought recovery of the entire $329,000 in attorney's fees, arguing that a portion of that was for the defense of the tortious interference part of the case, and then the rest of it was towards the prosecution of the conversion claim. The court did not rule in our favor in terms of the large bulk of it with the prosecution of the conversion claim, but did find that the defense of the frivolous counterclaim merited attorney's fees. And so for that reason, Vero recovered about 18% of its attorney's fees request for $61,526. In response, Gemino is arguing and relying upon the Hensley v. Eckerhart case. This is the 1983 Supreme Court case in which it does apply towards a civil rights action, but the general rationale says that if you have certain claims that prevail and certain claims that are not prevailing, that you can allocate your attorney's fees between the two claims, and the trial court in Hensley did not do that. There were some claims in that case that did not prevail, and so the court was sent back to make that allocation. It's really inequitable here because that's what the court did. The court made an allocation that said you recover the $62,000 for the frivolous counterclaim, and we're not going to award you the attorney's fees on the remainder. So Hensley doesn't stand for the proposition here that this court abused its discretion in awarding the attorney's fees. I see I have a couple minutes left. I'd be happy to answer any questions that you may have.
Okay.
Well, we asked that the court affirm the trial court's judgment. I wish I could fill up all 30 minutes of your minutes, but
That's okay.
Not a challenge.
Thank you.
May it please the court. Your Honors, just a moment ago, counsel for Vero stood up and said that Gemino was trying to fit this case into a narrow timeline. But that's exactly what Vero is trying to do here. And that's exactly what they're trying to do in preserving the problematic order that's in this case. In their brief on page 20, Vero says that Gemino's decision to sweep Vero's funds was a wrongful taking. But now they're arguing that at every stage, this was not necessarily a wrongful taking until they determined that it was. That's not what the law says. It's not up to Vero to decide when the conversion happened. According to the trial court's order, Vero had these funds, and they were supposed to belong to Vero. They were the lawful owner. The only case that Vero offers this court is the Hodge versus Young case. But there are a plethora of other cases that this court should consider. Stratton versus Royal Bank of Canada, Lockerman versus South River Electric Membership Corporation, North Carolina State Bar versus Gilbert. All of these cases stand for the proposition that conversion accrues and the statute of limitation begins to run when there is an unauthorized assumption and exercise of ownership that occurs, not when the plaintiff discovers it, and certainly not when the plaintiff has done a sufficient accounting to determine what money that they are owed. Ultimately, the theories that the trial court adopted here in its order are those that Vero advocated for, and they are just legally impossible based on the facts that they've offered. This trial court order from May of 2024 is inconsistent on the law. The law cannot result as the trial court found the facts, and to find otherwise is just contrary to our existing case law in this state. At the beginning of this, I told the court that this case really is about a party who didn't protect itself in a contract. The trial court ultimately held Gemino responsible for that. This court can take a step back and see the facts as the trial court has found them and the conclusions of law that simply do not flow. A review of the case law is very clear that the statute of limitations began to run on April 18th. Anything before then is barred, and the two sweeps after are not conversions. On that basis alone, this court can reverse on the law, and it should do so. Thank you.
Okay. Thank you very much for your arguments.
Good, awesome.